Westside versus Mergens, created by Emmons. Westside versus Mergens took place in Omaha, Nebraska, in regards to Westside High School. They are a part of Westside Community School District. The court case took place in the United States Court of Appeals in the 8th Circuit. The case to be discussed arose on January 9th of 1990 when it was taken to court. It was not until June 4th, 1990 that the official verdict was decided. Those who were involved were Bridget Mergens and other students who stood for the club. The case was formally against Bridget Mergens and the Board of Education of Westside Community School. Bridget Mergens wished to start a religious Christian club as a non-curriculum club on school grounds. She proposed that there would be no administrator involved so that no faculty came across as influential of the religion. The school denied her request, citing the establishment cause and school board policy requiring clubs to have faculty sponsorship. Petitioner school officials denied the request. Current and former students argued that the denial went against the Equal Access Act, which prohibits secondary schools that receive federal funding from denying groups that deal with religious, political, philosophical, or other content. Justice O'Connor delivered the opinion of the court with respects to Parts 1, 2A, 2B, and 2C, concluding that petitioners violated the Equal Rights Act by denying official recognition to the respondents' proposed club. Although the Act does not define the crucial phrase non-curriculum related student group, that term is best interpreted to mean any student group that does not directly relate to the body of courses offered by the school. A group that does not. For example, Subsurfers, a club for students interested in scuba diving, is such a group. Since its subject matter is not taught in any regularly offered course, it does not directly relate to the curriculum as a whole in the same way that student government or similar group might. The Act does not have the primary effect of advancing religion. There is a crucial difference between government and private speech endorsing religion, and as Congress recognized in passing the Act, high school students are mature enough to likely understand that a school does not endorse or support speech that merely permits on a non-discriminatory basis. Westside does not risk excessive entanglement between government and religion by complying with the Act, since the Act's provisions prohibit faculty monitors from participating and non-school persons from directing, controlling, or regulating attending and school sponsorship of religious meetings. A public secondary school has a limited open forum for whenever such schools grants an offering or opportunity for one or more non-curriculum related student groups to meet on school premises during non-instructional time. The Equal Access Act was passed by 88 to 11 in the Senate and 337 to 77 in the House of Representatives. It was motivated by the Supreme Court ruling in the Widmar versus Vincent case in 1981. Widmore versus Vincent took place at the University of Missouri when officials prohibited a religious group called Cornerstone from using the university buildings to meet on campus in 1997. During this case, Justice Lewis F. Powell, Jr. wrote the decision for 7 members of the court, affirming a decision by the Eighth Circuit Court of Appeals, which had reversed a federal district court's decision that upheld the restrictions. Justice Powell viewed the issue as to whether a university that had created an open forum could now exclude groups because of the content of their speech. An open forum in a public university does not confer with any state-approved religious sects or practices. In conclusion, any state interest in achieving greater separation of church and state than already ensured in the Establishment Clause of the Federal Constitution is limited by Free Exercise Clause and in this case by Free Speech Clause as well. In 1984, Congress adopted the Equal Access Rights. The First Amendment's Establishment Clause prohibits the government from making any law respecting an establishment of religion. This clause not only forbids the government from establishing an official religion, but also prohibits government actions that unduly favor one religion over another. In conclusion to the Mergens versus Westside court case, it was ruled in favor of Mergens due to the Equal Access Act that denied the prohibition of non-curricular clubs during non-instructional time, as well as the statement that the Establishment Act was not broken from lack of faculty influence and the separation from state withstood.